I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. We are here today at number 210 on our compilation list. We will be featuring 4 judges in this compilation. Before I give you their names, don't forget to like, comment, share, and subscribe. And let me say, I truly do appreciate all the comments. I try my best to read as many as I can and try to reply to as many as I can. So I appreciate you guys for commenting on the videos. It helps the channel out a lot, and it just shows me that you guys appreciate the videos. Remember, commentary will be left in these proceedings that had commentary in the past. Also, chapters will be added for your convenience. And now let me give you the judges' names and their courtrooms that we will be in on today. First, we will be in the courtroom of Judge Michael Fish out of the state of Indiana. And let me say something about Judge Fish. We featured him for the first time about 7 or 8 compilations ago for a proceeding he had. Well, this is a new proceeding and it's a short proceeding. And once you see how Judge Fish works in his courtroom, I figured you guys would want to see more of him. So for those of you that did not see when we featured him the first time, which was a longer proceeding, about 25 to 28 minutes, I'm also going to add that as well. So the first 2 proceedings will be in Judge Fish's courtroom. The third proceeding will be coming out of Dane County, Wisconsin. The third proceeding will be coming out of Michigan, and that will be Magistrate William Burton Jr.'s courtroom. And the last proceeding, which will be a continuation of the sovereign citizen that was in Magistrate Burton's courtroom, will be in Judge Larry Williams Jr. courtroom, obviously also out of the state of Michigan. So we have a lot here for you today. We are dropping this in the morning time on the day that it's coming out, so you'll have plenty of time to watch this whole entire video. Thank you once again. And now let's jump in to 210.
Prince Pugh, state would you please start the record?
Yes, Your Honor, thank you. This is State of Indiana versus Prince Pugh. The cause number is 64D012305, ISO F54448. Defendant is present in court in person by video conferencing, is here with counsel, Mr. Steve Provost, State of Indiana by Gary Gurman.
I think it's an F6, though. That's just a typo. It's definitely 2305 F64448. Morning, Mr. Pugh. Can you hear us okay?
Yes.
Okay, thank you. Mr. Provost?
Your Honor, I don't have anything new to report to the court. I haven't been able to see Mr. Pugh since he was rearrested on this matter. However, I have reviewed the pleadings that Mr. Pugh has filed, and I guess I'm looking to get some clarification from the court and Mr. Pugh as to my office's involvement in this matter, Your Honor. From what I've read, it appears Mr. Pugh is desirous of representing himself in this matter and has filed his own pleadings in accordance with that desire. But I want to be clear if, in fact, that is what he wants and if my office should be withdrawing from this case.
Well, what happened was I entered an order striking some pleadings back in November. There were some more pleadings that were filed. I struck those in last week. And then there were some more pleadings filed, and I have a motion, or an order rather, that strikes those. But while it was in the work queue, some more motions came in. So I needed to work on the order to strike the additional pleadings that came in. We don't allow for hybrid representation in this court, Mr. Pugh. So I've appointed counsel for you, and you need to file anything that would come to the court has to come through counsel. You can't file things on your own, sir. You understand that?
No, I do not understand that.
Okay, well, that's how it is. So anything you need to file has to come from your lawyer. And if it doesn't come from your lawyer, I will strike it from the record because we don't allow what we call hybrid representation. Okay.
I object.
Okay, we'll note your objection for the record, sir.
Your Honor, do we need to have any discussion with Mr. Pugh on whether he wants to proceed pro se?
I don't have a motion from him to proceed on his own and without counsel.
May I ask, I understand you're not going to address it today, Your Honor, but just so I'm clear.
I mean, he hasn't filed that motion.
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Pribble. Is that what you need?
Yes, sir.
Some more time?
Yes.
My Honor, are you aware that the respondent is a national citizen to the United States of American Republic, which is a sovereign government that has its own jurisdiction? Is the court aware of that?
Mr. Pugh, I'm going to set your case over for June the 12th at 8:30, and we'll see you back here then.
I object.
State of Indiana versus Michael Allegretti, 64 D01 2509 F2 10947. Defendant is pro se. State is represented by Deputy Prosecutor Hammer. We were set today for, I believe it was a FREDA hearing.
It is Ferretta. Mr. Allegretti wants to represent himself. So did you get a copy of our pro se representation form?
Yes, I did, Your Honor.
Did you have a chance to review that?
Yes.
Did you sign it and stuff?
No, I did not.
No? Do you have it with you?
No, I'm not going to sign it. I'm here, if I may speak, Your Honor. I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr. Allegretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No,
and you will have
finish
counsel.
talking?
I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Well, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire counsel.
I will not
if
be
you're
accepting
refusing.
that, Your Honor.
You are accepting it, sir. You know what direct
I wanted to
contempt of
put, I
court
wanted
is,
to
sir?
put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders that struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? You know what direct contempt of court is, sir?
Yes.
Direct contempt of court is when you are in contempt of these proceedings. And one way that you can be in contempt of court is if you refuse to answer questions and you delay the proceedings in front of this court.
Yes.
And you're refusing to answer questions that are as simple as, what is your address? And we need to know the address for the official court record. You understand that, sir?
Yes.
What's your address?
702 Indianapolis, Indiana.
What's the zip code?
46260.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Up to 6 months in jail with no good time credit. You understand that?
Yes, Your Honor.
Okay. So you're clear, I struck your frivolous proceedings from the record a few days ago, which may result in the denial of your request to represent yourself, which I have already done. Okay, so I denied your request to represent yourself. I've appointed counsel for you.
I do not understand those.
What'd you say?
I don't understand this proceeding, and I don't understand the charges.
I'll get back to that in a minute.
Okay.
The second thing I notified you is that I may exercise my inherent authority to impose filing restrictions on you to prohibit you from filing any future pro se documents without prior judicial screening and approval. I've taken care of that because I've appointed counsel for you. And you're not allowed to do what's called hybrid representation. You're not allowed to also file things at the same time you're a lawyer's filing things, because they're responsible for anything that would come to this court. Do you understand? So any motion
I do
that
not
they would
understand.
file. What did you not understand the words I used or what they mean?
Everything.
What's your level of education, sir?
I didn't. I had some college.
Okay, so you graduated from high school?
No, I did not have a GED.
You have a GED? So you graduated from high school? You have a equivalency
Yes.
of a high school graduation?
Yes.
Okay. So what I said was that you're not allowed to do hybrid representation. Do you know what hybrid means?
Nope.
Hybrid means that there are two ways, right? Hybrid would give the understanding that you're also representing yourself pro se at the same time you have a lawyer.
I do
Understand
not
what
have a
that means?
lawyer though,
I just appointed a lawyer for you.
but I don't want it.
You have it because I denied your right to
I can't
represent
afford
yourself.
one, and I don't want a court-appointed attorney that's represented under the Bar Association.
Sure, the first words you told me was that you don't plan to submit yourself to the jurisdiction of the court. As a result,
I wasn't able to finish.
I
said as a defendant.
well, sir, you have to submit yourself to the jurisdiction of the court. That's the kind of nonsense that I think you're involved now with some program that you probably don't want to be if you want to try to represent yourself in front of this court. But in any case, the third thing I told you is I can impose further sanctions for contempt or abusive litigation practices upon you. You understand what that means?
No, I do not.
I can hold you in contempt of court for delaying these proceedings, and I can sanction you for abusive litigation. All right? And the fact that you've now tried twice to file the documents that I've had to strike from the record tells me that you're willing to be an abusive litigator. Do you understand that?
I do not.
Okay. So I have time that I work on cases. Everything's pretty streamlined for the most part. People understand how the rules work. When they represent themselves, they make themselves apprised of all those rules, and they're held to the same standard that lawyers are held to. As a result, things run fairly smoothly, and we have some thousands of cases that we handle each year. Because people follow the rules, they abide by our processes, we're able to get our work done in a relatively streamlined fashion. What you're suggesting to me is that I shouldn't do that. What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedure of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know
Your
why?
Honor, but if you
Because
just let me
it
finish.
doesn't follow the rules of court procedure. And
But I'm in
therefore,
equity, Your
you're
Honor.
going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand the proceedings and the charges of this matter or the proceeding.
Okay, sir.
I just want to put that on the record.
Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I have the day off of work.
say what?
I have the day off of work. I can stay.
Okay. So count one says that you're charged with dealing cocaine. It alleges that on or about September 28th, 2025, here in Porter County, you did knowingly or intentionally possess with the intent to deliver or finance the delivery of cocaine or narcotic drug, and the amount was at least 10 grams, contrary to the form of statute. You understand the charges in count one?
No, I do not.
What do you not understand, sir? The words I used or what they mean?
What is the definition of understand in the law?
Sir, you have to just acknowledge whether or not you understand.
I don't understand, though.
Which part do you not understand?
I don't understand all of it.
Okay, well, let me go through it again. Count one suggests that you dealt cocaine, a level 2 felony. You understand what a date would be, September 28th of 2025?
I still don't understand.
Sir, do you not understand what date would be, September
I
28th
understand
of 2025?
I accept your date, but I don't understand the natures of these charges.
Okay, sir, you're about this close to being held in contempt of court. You understand that?
I understand, Your Honor.
And if you're held in contempt, I'm going to put you in jail, sir. And I'm going to jail you.
Why are
until
you
tomorrow.
forcing me to understand the charges?
I'm not forcing you to, sir.
Yeah,
I'm just
if you're just going to give me an
trying to
attorney.
go through the statutory and constitutional procedures required of me in this court. And that's for me to make sure you have a knowing and voluntary, well, not knowing and voluntary, but you have an understanding of the charges filed against you. It's part of your constitutional requirement.
And if it is, I do have rights too, right?
Well, I've gone through your rights with you. You understand that you have certain rights in this case?
Yeah, do not.
I'm
Do
required to advise you of your various rights in this matter.
Am I
You have the
allowed?
right to hire an attorney to represent you. You understand that?
And I do want an attorney.
Well, you understand that you have the right to one, or you wouldn't be able to suggest that you don't want one, correct?
I don't want one.
So you
I don't
understand
want-
you
I
have the
don't-
right to one, correct?
Correct.
Okay. And you understand that if you can't afford one, the court will appoint one for you, correct?
If that's what you say.
Oh, no, sir. You either understand or you don't. You understand?
I understand that you want to give me a court-appointed attorney.
No, 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 no. I already appointed a court-appointed attorney for you because you can't get through the Feretta hearing. You understand why you can't get through the Feretta hearing?
No, I do not.
What were the first words out of your mouth when you read off your card earlier?
I said I'm in propria persona,
And then?
especially and not generally. I do not submit to the court's jurisdiction of the court as a defendant.
And that's all I need to hear, sir. That's all I need to hear. Because if you're not willing to submit yourself to the jurisdiction of the court, you cannot represent yourself in front of this proceeding. Do you understand that, sir? You know what jurisdiction is?
Yes.
Tell me about it.
You think that you have jurisdiction over my body and I'm a living human
What does
being.
it mean, sir?
Are you here to practice court? Are you, I don't understand what this has to do with anything.
I'm asking the questions, and I don't care whether you think you understand it or not. You've come up here with your sovereign citizen.
I'm not a sovereign citizen. I did not claim to be a sovereign citizen.
Trying to bring
I'm using the law in equity.
confusing sort of pseudo-legal jargon into the court, arguing things that aren't even based on criminal law.
I didn't even get to
And
finish my
suggesting
statement.
that you're not willing to subject yourself to the jurisdiction of the court.
I didn't
As a
even-
result, you can't have a lawyer. I'm sorry, you can't represent yourself. You have to have a lawyer, somebody who understands how the court proceedings work and is an officer of the court already. You understand that?
No, I do not.
Which part don't you understand, sir?
Everything. I can't even state my statement. I want to just put my statement on record.
You're not willing to subject yourself to the jurisdiction of the court. You're not capable of representing yourself, and you must have counsel.
I said as a defendant, Your Honor.
Sir, I don't care how you try to qualify it. All right, sir, do you understand the allegations in count one
No, I do not.
related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me what do you not understand.
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Allegretti, is find that you've unduly delayed these proceedings.
All I want to do
Find
is
you in
speak my-
direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Your Honor, I have
contempt.
a job.
Please take Mr. Allegretti into custody. We'll try again tomorrow, sir. We'll be adjourned in F2-10947, and I'll open a new case on the contempt proceeding. Lawyers are trained to recognize objectionable and unfavorable evidence and promptly object to their use. They're capable of presenting, as I mentioned, favorable sentencing information and attacking unfavorable sentencing information. In a jury trial, a lawyer will give an opening statement and make a closing argument, and they're capable of doing that very artfully. Have you ever had experience speaking in front of people?
I'm doing it right now.
Have you ever had experience speaking in front of a large group of people?
Yes,
such
I
as-
have.
Okay, tell me about that.
I can't remember.
Okay.
I don't know how to articulate it is what I actually mean.
Well, you would articulate it by telling me what experience you have.
I've been in front of people where I've spoke to a group of people before,
How many people do you think were in that group?
at least 25 plus.
Okay. And how many, how
It's a
often,
presentation.
how often have you had the opportunity to do that?
More than a handful of times.
How many is more than a handful? 6?
I have no idea. I cannot give you, that would be lying.
Okay. The other thing that a lawyer would do in a trial is help the court prepare jury instructions and select a jury. You understand how to select a jury?
Yes,
What would you do in that circumstance?
I would cross-examine them.
You would. Lawyers have the training, knowledge, and skill at properly preserving the record of a case for appeal. Have you ever been involved in an appeal?
No.
An attorney can also evaluate the strengths and weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement, which might result in a dismissal of some of the charges or a recommendation of a favorable sentence in return for your plea of guilty. This is an important part, and I would ask you to take note that you will, if you decide to not have an attorney, you'll not receive any special treatment with your defense. You'll have to follow all the same rules and procedures in your case as an attorney would have to. The state will have a competent attorney. As I told you, you have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost would always decide to be represented by another lawyer in a criminal case. There are some of the things that you should consider before you appear at trial without an attorney, and I want to go through a little bit more now. Tell me more about your skills and knowledge that you have that you believe would be helpful in representing yourself.
Where do you want me to begin? Ask me a question and I'll answer it.
I ask you a question, sir. What skills or knowledge do you have that would be helpful to you in this regard?
I'm able to learn quickly and I know I can represent myself.
What's your college work? And you mentioned you had some college work.
Personal training as a personal trainer.
Okay, like in a gym or something like that? When you work in the gym, do you work with people, interact with people?
Yes, all the time. I did.
Do you still have that job?
No.
What other work have you done? What other career have you had?
I worked at a pharmaceutical company where I led teams. I developed drugs and I was promoted multiple times as team leader to a supervisor.
To what degree did you lead people?
We led multi-million-dollar studies that had my name attached to those, to where I had a lot of responsibility and I had to learn fast and move fast.
Have you ever studied criminal? Go ahead.
Well, I never was in the pharmaceutical company, so I learned fast and I only had that job for 3 years, and I was able to propel myself that quickly with the little knowledge I had.
Have you ever studied criminal law?
I'm studying it now.
Have you ever studied criminal law previous to now?
No.
Have you ever had previous experience in the criminal justice system?
Yes.
What's the experience you've had in the criminal justice system?
When I was dealing with previous cases in the early 2000s.
Okay, tell me more about that.
I submitted to whatever the court told me to do. What do you mean?
What type of case were you involved with?
Drug cases.
Okay. And is that a case or cases where you were charged with crimes?
Yes.
And are those cases where you came to court?
What's that word mean? Caped, where they represented me?
I said came.
Oh, came, sorry.
Came to court? Did you have to come to court for those?
Yeah, yes, I did.
And did you have an attorney?
Yes, at that time.
Okay. Did you go to trial?
No.
So what was the result of the case?
I pled guilty to those charges.
Okay. Is that the limit of your experience in a criminal case?
Yes.
All right. You believe you're able to read a lot of information and
Yes.
adjust a lot of information?
Yes.
What about your writing ability?
Yes.
Tell me more about your ability to write.
I wrote up all those. I wrote up all those notices. You didn't read them?
You wrote some documents and
Yes.
filed those with the court on 2 separate occasions.
Yes.
I struck both of those filings from the record because.
Yes. But that's the degree that I'm on.
Okay, so how did you compose those?
I wrote them.
And what did you use as reference?
Equitable law.
Okay, you understand this is not a court of equity?
You're telling me that that all courts are not with equity? No court in Indiana is equitable?
This is not an equitable proceeding here. Absolutely not. This is a proceeding at law.
Okay. Well, I represent myself under equitable law.
Well, we make I think, fine distinction in Indiana between what are equitable cases and what are cases at law. And this one most assuredly is a case at law. You're entitled to a jury trial. You understand that in an equitable case, you're not entitled to a jury trial? You understand that?
Yep.
You do?
You're telling me now.
Okay.
I'm learning as I go.
Okay. You understand that if you represent yourself, you'll be proceeding as the single legal entity named in the charging information, specifically Michael Corleone Allegretti.
That's not my name.
You understand that the court won't entertain any arguments to the contrary.
If that's what you're telling me.
Okay. Is that a yes or a no?
I understand that.
No. What I asked was whether or not you are aware that the court will not entertain arguments to the contrary. Your name is Michael Corleone Allegretti. That is your legal name.
That's not my legal name. I changed it.
Do you have documentation that you
Yes,
changed
I
your
do.
name? Please don't cut me off.
I'm sorry.
Where did you get that documentation?
In Michigan.
In the state of Michigan?
Yes.
You have a court order that changes your legal name?
Yes, I do.
Where's that documentation?
In my files. I had it in my possession yesterday.
Okay. Well, in this order today, will order you to provide the change of name
I will.
order from the state of Michigan to the court
I have no problem.
within, say, 10 days.
I can do it today.
And then, well, I'm going to give you 10 days.
Okay, thank you.
And then have you not changed your driver's license?
Not yet. I'm still in the process of doing everything.
When did you have the hearing that resulted in the name change?
I put it on my documents when I gave you the notice of intent. I put it on my documents then. Do you still have the copies?
How recently was it?
I don't remember the exact date.
Did you have to go to court in Michigan for it?
Yes.
You don't remember when it was?
I don't know the exact date, no.
Were these charges
I gave you all the documents, sir.
Were these charges already filed at that time?
Yes.
You also, in those filings, suggested you're making a special appearance or that you do not consent to this court's jurisdiction. You understand that in a criminal proceeding, your personal consent to the court's jurisdiction is not legally required.
Say it again.
Do you understand that in a criminal proceeding in Indiana, your personal consent to the court's jurisdiction is not legally required?
No, I don't understand that.
Okay. Do you understand that the state of Indiana has jurisdiction over the charges filed against you, and this case will move forward regardless of whether you agree with that jurisdiction?
I don't understand that either.
Okay. You seem to be clever enough to understand these things. I asked you earlier whether or not you're suffering from a mental health condition. I predict that at a certain point, if you continue to suggest you don't understand simple terms, that your attorney will suggest to me that I need to have you evaluated for competency. Do you understand that that's a possibility here?
Nobody's speaking for me. He's not my legal representation.
Oh, he is. Do you believe that you are incompetent and incapable of proceeding on because of a mental incapacity?
No.
Do you believe you understand the players in the courtroom?
What players?
Do you believe you know what I do as the judge?
I believe you're an actor.
The other thing that you put in the record, you attempted to apply concepts like suretyship, subrogation, demands for accounting, and different things like that in these criminal charges. And as recently as a few minutes ago, insisted that you're dealing with an equitable case here. You understand that the Uniform Commercial Code, civil contract law, and commercial equity have absolutely no application in this criminal prosecution?
I'm just here to settle the matter and put my stuff on record that you already struck. How come we're going over it if you already struck it?
Sir, it's an important part of the Ferretta determination. I can't allow you to represent yourself if you can't answer affirmatively to these questions. And you've already not answered affirmatively to 2 out of the 4 that I have here that I want to make sure that we go through. You understand that?
No.
Okay. Well, what I said was, and I just want to make sure our record's clear, the UCC, civil contract law, commercial equity have no application in this criminal prosecution. And you understand that the only rules that apply here are the Indiana rules of criminal procedure, the Indiana trial rules as they're brought into those criminal procedure rules, Indiana rules of evidence, and substantive criminal laws of the state, along with various other administrative rules that we have to abide by, including our jury rules. You understand those are the only rules that apply in this case?
I understand now.
You do understand?
I understand what you just said.
Okay. You understand that if you are allowed to represent yourself, you'll be held, as I mentioned, to the exact same standards as a lawyer, as a licensed attorney.
Am I ready to talk? I'm sorry.
I'm just waiting on your response.
Oh, yeah. Yes.
And you understand that I will not permit you to waste the court's time or the jury's time by raising the theories that you've raised thus far, commercial law defenses, or challenging, say, the capitalization of your name, for example.
Do you want me to answer?
It was a question. You
Yes.
understand that?
Yeah.
And you understand that if you attempt to use your self-representation to file frivolous documents, disrupt proceedings, or refuse to follow rulings on issues, I'll find that you've forfeited your right to represent yourself and will appoint counsel to take over your defense.
Are you going to give me examples of frivolous? Because I won't know until I file them.
Well, the 2 attempts you've made to file documents previously were both deemed to be frivolous.
So should I just bring them to you directly and then you'll let me know?
I haven't made that ruling yet to require screening before filing, but it's on the horizon if you continue to file things that have nothing to do with the criminal case. Okay. So because you answered no to the first couple questions, you really aren't capable of representing yourself. And I do think that my ruling yesterday was correct. It seems that you're unable or unwilling to abide by the rules of procedure and substantive law. And I don't think that you can make a valid waiver of counsel. The court had spent some time yesterday afternoon reviewing a case, Hotep L, v. State of Indiana. And I think that's an adequate Feretta inquiry. Again, I think I must deny your request to proceed pro se. The court does not, well, I'll phrase it the opposite way. The court specifically finds the defendant's request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert these proceedings. Defendants utilizing the rhetoric of what is commonly referred to as the sovereign citizen movement, including raising nonsensical challenges to subject matter jurisdiction, attempting to apply commercial law to a criminal prosecution. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based upon the filings that were previously stricken and the statements in open court today, court finds that the defendant's unwilling to comply with the rules of procedure and intends to use self-representation solely for the deliberate disruption of the proceedings. So I will deny the request to proceed pro se. I will maintain the appointment of counsel of Mr. Patton. And I think that will do it. We need to get some hearings. We need to get a hearing on the calendar.
I want to object to your ruling on the record.
So noted. Did you want to add anything to your objection?
I know I can represent myself.
I have to have a city council back.
I'm sorry, who do we have here? This is Mr. Griffin.
Anthony. I asked for assistant counsel, not counsel.
We'll go on the record in the state of Wisconsin versus Anthony Griffin Jr., case number 25CF 939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the state of Wisconsin.
And you're Mr. Griffin, is that correct?
No, I'll say Mr. Eric comes now the living man, Anthony of the Griffin family. Sir,
All right, so Mr. Griffin,
appearing expressly.
wait, you need to stop talking.
I'm
Is Mr. Griffin
appearing expressly.
hearing today? Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin
executor of the
that is
estate
charged?
of
Stop a
Anthony.
second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
All right, 25 CF 939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later
I will
hearing.
as I have been held for 72 hours without seeing a judge. That is unlawful.
But you're not Anthony
So
Griffin.
you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this, okay. I'm gonna find probable cause that this is Mr. Griffin, that is acting in an obstructing way, but,
I object to
we'll go ahead
my
with it. Do you have a
justice.
copy of the complaint there in front of
I
you?
object that you're obstructing my justice.
Your objection is noted.
I'm a more. You have.
If you keep talking over me, we're gonna cancel
You've been
this.
talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
And you're not allowed, no, you're not allowed to talk about it.
Of attorney. I am not.
Okay, let's hold him in custody, or canceling this hearing, you're gonna have to be
That's
held.
okay.
You're not willing to cooperate. Make a
Let the record show that they're violating my rights. Let the record.
Record will note that he refused to cooperate so that an initial hearing could be conducted. That's 25 CF 939 appearances.
88 Cicely DeMarco for the state.
Understand order the Public Defender's Office defers to Mr. Griffin, who's indicated that he wants to take care of his own case.
Right, is that right, Mr. Griffin?
No, I'm not Mr. Griffin. I'm Anthony of the Griffin family. I am the power of attorney for him. I am not. I do have a question for the court. Will I be allowed to speak freely, or will my civil rights be again granted over?
Oh, you gotta make a statement on bail, but we're gonna do this in an orderly fashion, but you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself?
It's not about me identifying myself and the Griffin in all caps entity with the dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a black man. I am on board. So a lot of things on here are totally wrong, which not be at all. My weight is not 240 pounds. All this information is false. As for the record, all statements for the record comes now the living man and the other Griffin family. Sure, your appropriate persona status appearing expressly to continue to arrest accordingly. I'm not to be mistaken with the all caps estate, as I am the occupant of the executive office and also the sole beneficiary of the state. I filed my power of attorney with the court, and I'm ready to proceed. Let the record show that I do not agree to be a surety for the dead entity as it was created from the state and was given to me, and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I missed support was due to the failure of the court to notify me of said date. Furthermore, upon being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued with the arrest as a violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while traveling in a private automobile. The plates read, DOT exempt, do not detain private travel. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of coercion after I told them I did not want my fingerprints or paper taken until I have a court order from the judge. I do not argue with any of the facts in this charging incident. This is not me taking a plea. This is accepted for value and returned for value. All the charges contained in this case, and use my exemption for discharge and set off and release the order to me immediately.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffin is the same individual in front of me. When they call Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now, sir. You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about.
That's
I've never
okay.
heard that ever.
That also means that this
You
is not
can file your written motions,
not a
Mr. Griffin.
competent court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the Spillman records match this particular individual. I'll find probable cause.
Man can be awarded over his own case.
And where would you like us to send mail, sir?
You already have mail. I'll tell you on file. It's P.O. Box, DeForest, Wisconsin,
Okay,
53532.
thank you.
And I have a right to be
What's
cognizance.
what's the state's position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 cash bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the respective statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of bond conditions.
I object.
It's our position that
Let her finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
The
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection is overruled. I ruled it, Mr. Griffin. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So, Your Honor, they're sure not that when somebody has a court date that they have to be served a court date so they know that it's there? Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for warrant?
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no document or proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that. And I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was, I don't know, hiding in the back or whatever the case may be. I filed an abatement just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not going to be doing any of that, Mr. Griffin.
And she is not the state. I know her not. So I don't understand what's going on.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But you're gonna have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body only warrant. You can't get released on that until you have a hearing with Judge Highland in that case. I think given the history, $1,000 cash bail is necessary. I will set that.
I object. And it's clear
And that's
that
fine.
rights have been violated and you're still moving forward. This is called an obstruction of justice.
Don't
Let
think
the
that
record
your
show
rights have
that.
been
Know
violated.
everything that I've said.
It's all being recorded, Mr. Griffin.
Glad.
You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
Well, I don't want to sit in jail any longer.
Okay, well, you're gonna have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, then
You're gonna have to address
I object
that
that you don't
case
have
with him.
authority to actually set me a bail. You do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
You're
statute.
responsible for that.
And because I haven't heard a response, I don't believe we have a waiver of time limits to set a time.
Are you responsible for me if something happens?
And we are adjourned.
Okay, since you're not responsible for me if something happens to me, let the record show that you are not. You are crazy. Bad communication, us.
Well, guys, we've come to the end of both of these proceedings. It ended up being two proceedings because Mr. Anthony Griffin did not want to cooperate, and definitely what was said about him being arrogant, being unruly, definitely was a fact. As we can see in that first appearance, I mean, the disrespect that he showed the defense attorney, the public defender, he just kind of shoot him off. That was pretty disrespectful. But anyway, he kept trying to talk over the judge in the first proceeding to the point of where he didn't want to identify himself. He didn't want to cooperate. So the judge, passed the matter into a later date. We see with the second judge, same thing. He wants to go back and forth. He does say that the reason why he missed court is because Judge John Highland did not send him the proper notice on his, on them wanting him to appear in court. But the judge said that it was sent to the address he provided, but who knows? There's always something going on with the whole, I didn't get this or I mailed that. So it's like, who knows? I don't want to say that he's lying and I don't want to say that he's telling the truth, but nonetheless, he kept up, a lot of the unruly behavior. And he even said that, the prosecutor, I don't know her. She doesn't know me. I want her to get on the stand and tell me how she knows me. And my thing is this guy, he's willing to seems like he's willing to stay in jail just to get everything that he has to say on the record over something that seems to be pretty petty. Is it worth it? I don't think so. But to him, it is. And, this is where we are. So he can't even bond out until he gets that other matter fixed before Judge Highland. So we will follow this case and hopefully be able to update you on it. But with that being said, guys, thank you always for joining me. Don't forget to like, subscribe, and share. This is Sovereign Citizens Hall of Fame, guys. And for now, Sovereign Citizens Court is adjourned. I appreciate you guys. Talk to you soon. God bless.
Mr. Reynolds?
Judge, what was that preliminary exam date? You said 12/27 and then 1?
January 3rd.
Yes, we're ready,
Mr.
Judge.
Reynolds?
Yes.
Okay, Mr. Reynolds, state your name.
Your Honor, if I could probably clear this up, Mr. Reynolds is objecting to a video arraignment at this time.
Mr. Reynolds, state your name. Irvin Reynolds. This is case number 240608. Mr. Reynolds is being charged with count 1, felonious assault. Did make an assault upon Elisa Jordan Smith with a dangerous weapon, and a pistol, without intending to commit the crime of murder or to inflict great bodily harm less than murder, contrary to MCL 750.82. A 4-year felony and or $2,000 fine. Count 2, weapons felony firearm. Did carry or have in his possession a firearm with a pistol at the time he committed attempted to commit a felony to it, felonious assault, contrary to MCL 750.227B. 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of weapon or device. Count 3, domestic violence. Did make an assault or an assault and battery upon Alyssa Jordan Smith, an individual with whom he had a dating relationship, contrary to MCL 750.81 subparent 2. That's a 93-day misdemeanor and or a $500 fine. A consecutive sentence may be imposed on MCL 750.506 sub small a if the assault was committed in a place of confinement, as well as habitual second offense notice. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
And again, Your Honor, Sydney Rushing, P78830, on behalf of Mr. Reynolds. And again, Your Honor, I'd just like to advise the court, my client is objecting to a video arraignment. He would like to be arraigned.
Noted for the record. Noted for the record. Bond recommendation, Mrs. Coyle.
Your Honor, based on, he's currently on a parole hold. He has a parole violation, is returned to MDOC for he has a murder 2 out of 1992. He got 25 to 40. He was paroled in April of this year. This occurred in October of this year. As the court notes, it's highly assaultive, threats of death, with a weapon. The complainant's statements are corroborated by the officer noticed a scratch under her chin. Also, they found the weapon in the backyard where he was detained once he fled from the officers. So for these reasons, Your Honor, although I know he's on a parole hold, he's likely going nowhere based on the allegations, based on the assaultive nature. And I believe my guess would be the violation is the new case, but I'm not sure. So I'm going to ask for a $50,000 cash surety and a tether if he is released, tether house arrest, but likely I have a feeling this is what the parole is about.
Ms. Rushing?
Your Honor, we'd be asking Your Honor to consider a lower bond. That is an unaffordable bond. Again, my client is located at the Michigan Department of Corrections currently. So we're asking you for consider a lower bond. I believe a GPS tether is the least restrictive means if Mr. Reynolds is able to be released prior to the conclusion of this case.
Okay, for clear, convincing reasons, I find Mr. Reynolds a danger to the complaining witness and to the community. Based on a review of the investigator's report, there was an assault with a pistol. And then what is troubling, in the last sentence of the first paragraph, the victim stated, "He has my gun and he said he's going to kill me." And given his prior murder conviction, I believe he has great ability to carry out the threat. And so for those reasons, I find he's a danger to the community. I'm going to adopt the recommendation of the people, $50,000 cash surety. While his case is pending, he's not possessing any handguns, firearms, other dangerous weapons, no contact with Lisa Smith. If he's able to post bond.
Excuse me, Your Honor. Excuse me, Your Honor. I don't mean to be rude and interrupt, but
it's too late for that. It's too late for that.
Well, I mean, y'all got a whole other thing going on here. She don't represent me. She not my.
Okay. Give me one moment. Woo! Fun Friday. Okay. Okay, Mr. Reynolds, I just want you to listen. You're given a $50,000 cash surety bond, which is, I presume, an unaffordable bond. I find that you're a danger to the community. You'll have a bond redetermination hearing Monday, December 23rd, in front of Chief Judge McConicle. Well, you have a bond return. That's 9 a.m. in front of Chief Judge McConicle. Probable cause, December 27th, preliminary examination, January 2nd, in front of Judge Sabri. You have any questions regarding your bond conditions and or court dates?
I have a question concerning, what is this proceeding? Is this an arraignment?
Yes.
This is an arraignment?
You just been arraigned.
Okay, the thing I'm trying to explain is she not my attorney. She don't represent me. Okay. She been speaking on my behalf, and she not my attorney.
All right, who's your attorney then?
I'm representing myself, and I'm making a special and limited appearance.
What's your bond argument? What's your bond argument?
I don't have a bond argument. I'm making a special and limited appearance. Just to challenge the subject matter jurisdiction of the court. And I'm telling you, this court don't have jurisdiction of the principal subject matter. which is the attachment action that the prosecutor filed.
Well, guys, we've come to the end of that first proceeding before Judge Burton. And as we can see, like I told you guys in the beginning, that Mr. Reynolds is facing some very serious charges. As we can see, he did a murder bid in the past. And because of what he is in court for now, he is now in jail on a parole violation. Judge Burton has deemed him to be a danger to the community. So even though he's in there on a parole violation, which he probably won't be able to get out because of the parole violation until that's settled, they still want to make sure that they have a bond there just in case, because Judge Burton says, listen, he's a danger to the community. I don't think he should be out. With his past history, with his current history, we see he keeps talking about wanting to be arraigned in person for whatever reason. And it's probably to do with some type of, maybe something he knows or understands about the law, or it could be some type of sovereign citizen thing. So with that being said, guys, let's go ahead and let's jump into this second proceeding.
We're ready to roll. The gentleman that's in the Michigan Department of Corrections facility, can you tell me your name?
My name is Irvin Reynolds.
All right,
and,
thank you.
I'd like to say that coming in, that I'll make a special and limited appearance just to challenge the subject matter jurisdiction of the court. And I'm saying that the court doesn't have jurisdiction of the principal subject matter, which is the writ of attachment that the prosecutor's office filed.
All right, your objection is noted. 1 second here. All right, this is State of Michigan versus Irvin Reynolds, case 24060877701. Today is the date set for a bond redetermination hearing. Can I have appearances, please?
Good morning, Judge. Steve Vincent for the people, P71917.
Good morning, Jessica Shipe, number 81798. On behalf of Mr. Reynolds, sir, can you please state your full name for the record?
She's not my lawyer, Your Honor. This is an arraignment proceeding, right?
Mr. Reynolds, do you wish to represent yourself?
Is this an arraignment proceeding?
This is sort of like an arraignment. This is like a you are arraigned, and this is a hearing to see if the bond.
Hold on, you said I was arraigned?
Okay. So
did you just say I was arraigned?
Your Honor, may I step in? I see some notes here.
Well,
I haven't been arraigned.
Can I stop everybody right now? Ms. Shibe, if Mr. Reynolds is indicating that he's not your attorney, then I'm going to ask that you hold tight right now. Mr. Reynolds,
I haven't been arraigned.
Sir, listen to me for a second. I'm trying to straighten this out. You indicated that you have not been arraigned?
Mm-hmm.
All right, 1 second. Let me take a look at what's in the file. Hold tight.
Yes, and I do have notes, so not on behalf of him, just to help the court.
I appreciate that. But let me see where we can get to. Hold tight, Mr. Reynolds. I have to look something up real quick. All right. So the system says that it was arraigned, but if that's a mistake, Ms. Shibe, you indicated that you had some additional notes.
Yes. So the notes that I have, it looks like Mr. Reynolds did want to represent himself. He was spoken to and told his rights and all. And it looks like he was Okay. It looks like he was objecting to being arraigned without being brought in person. It says that he wanted to be arraigned in person and he was objecting, but I do see that a bond was given and new dates were given. So it said no video arraignment. So I believe it was done without, he wanted to come in person.
Well, I would say this, Mr. Reynolds, I would say this, that's fair. If you want to be arraigned in person.
Hold on, wait a minute.
No, stop. You have the right to be arraigned in person.
They cut
Listen to me. I'm going to stop your audio because you're not listening to me, and I'm not going to go back and forth with you. I'm indicating if you want to be arraigned in person, I am going to order you arraigned in person. And we're going to stop all this. If you stop talking over me, wouldn't have this back and forth. All right. So I'm going to set an arraignment date. Let's see, today, the next date they have in front here for, looks like there's an exam date scheduled for January 2nd, 2025. We're going to have the writ signed for you to be arraigned on that date. We'll see if that's enough time to transport you to 36th District Court for your arraignment, and then we'll take a PCC from there. So we'll schedule this for an arraignment January 2nd, 2025 before Judge Sabri. That's going to be your next date, sir. And we're going to have a writ to bring you down to 36 for that hearing.
Well, guys, we've come to the end of both of these proceedings. On the second proceeding, not a whole lot to comment on, but I will say Judge Larry Williams Jr. handled himself well. Had to pretty much shut Mr. Reynolds down for his own benefit because, you know, he constantly was talking about he hasn't been arraigned, which technically he had been. But like Judge Williams said, he has the right to be arraigned in person. So that's what they're going to do on his next appearance. Hopefully we can get that appearance. And if we get it, as always, we will most definitely share it with you guys. But with that being said, guys, once again, as always, don't forget to like, subscribe, and share. This is Sovereign Citizens Hall of Fame. This is also Sovereign Citizens Court, guys. And for now, Sovereign Citizens Court is adjourned. I'll see you guys soon. God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.